Hi, welcome to day 2 of the CGLR and Giffords Law Center and CJP Symposium. I'm Justin Van Leyen. I'm one of the co-editor-in-chiefs of the UCLA Criminal Justice Law Review. I'd like to start with a land acknowledgement. The CJP and CGLR at UCLA acknowledges our presence on the traditional, ancestral, and unceded territory of the Gabrielino and Tongva peoples. And now I'd like to pass it over to Professor Beth Colgan for opening remarks. Dean Colgan is the Vice Dean of Faculty and Intellectual Life here at UCLA Law and Faculty Director of the Criminal Justice Law Review. She is one of the country's leading experts on constitutional and policy issues related to the use of economic sanctions as punishment, and particularly on the Eighth Amendment's excessive fines clause. So everyone, please welcome Dean Colgan.
Good morning, everyone. Thank you so much for being here. I am absolutely delighted to and very briefly kick off this morning's events, which are chock full of exciting speakers and panels. And let me just start by thanking two groups in particular for their generosity, time, and effort in working with the Criminal Justice Law Review to put on this symposium event. So UCLA Law's very own criminal justice program, as well as the Giffords Law Center, which is a San Francisco-based gun violence prevention program led by former Congresswoman Gabby Giffords, which has been at the forefront of analyzing gun safety laws and Second Amendment issues for nearly 30 years. I'd also like to thank several key sponsors who made the symposium possible: UCLA Law's Career Services Office, our Critical Race Studies program, our Student Bar Association, the David J. Epstein Program in Public Interest Law and Policy, and Rutten and Tucker LLP. So as you know, we've gathered here today to talk about the Supreme Court's June 2022 decision in New York State Rifle and Pistol Association versus Bruen. By a 6-3 vote, the Bruen court struck down New York's century-old public carry licensing law that required a person to show a proper cause before obtaining an unrestricted license to carry a concealed firearm. In doing so, the court announced a new framework for evaluating Second Amendment challenges focused on historical tradition. And as we're now seeing, the lower courts have begun relying on Bruen and that framework to strike down firearm restrictions. This, of course, is all happening against the backdrop of two important and potentially competing concerns. First, we as a nation are now suffering more than 45,000 gun fatalities each year. Our headlines are full of horrors, from a supermarket in Buffalo to an elementary school in Uvalde to a 4th of July parade in Highland Park and a house of worship in Laguna Woods here in our own backyard. What gets less attention are the individual incidents of violence that make up the bulk of gun-related deaths. And gun-related homicide deaths, of course, fall disproportionately on young Black men, who make up 52% of all gun homicide victims, despite being less than 6% of the population. Second, at the same time, the negative consequences of policing related to guns also falls disproportionately on heavily policed communities of color. So not only does that mean that people of color, in particular young Black men, are disproportionately prosecuted for illegal gun possession, we also should not forget how legal possession of a gun by a young Black man can play out, as it did in the police shooting death of Philando Castile. Rich, robust, critical examination of these complicated issues are essential for us to be having, and I'm glad we're having them here at UCLA. I'm pleased that in today's 4 panels, we're going to be joined by scholars, community activists, and attorneys from across the nation. So thank you all so much for joining us. And now let me just take a brief moment to introduce the moderator for our first panel, Esther Sanchez Gomez. She's a graduate of the University of Arizona James E. Rogers College of Law, former clerk for the Honorable Rosemary Marquez of the U.S. District Court of the District of Arizona. She joined the litigation team at the Giffords Law Center in 2021 and now serves as its litigation director. So please join me in welcoming her.
Thanks, everyone, for being here. I think I'll just invite the panelists up, and we'll get rolling. Hi, everyone. Thanks again for being here and for participating in this important conversation. We're running a bit behind, so I just want to say on behalf of Giffords Law Center, we're really excited that folks are interested in talking about gun violence and about what we can do to solve the gun violence epidemic in this country. So, as you heard, and as you're going to hear many times over today, this past June, the Supreme Court issued its first major Second Amendment ruling in over a decade. Justice Clarence Thomas wrote for the majority in a decision that completely overhauled the methodology used by courts considering constitutional challenges under the Second Amendment. History is now in the spotlight, forcing litigants on every side of the issue to appeal to history a history for which our understanding is not static, and for which the record is continuing to be supplemented, but also a history that is clear in one important way. Much of early American gun regulation was dedicated to disarming people of color, particularly Native Americans and enslaved people. Our panelists today will shed light on the court's decision, what it means for firearms regulation, Second Amendment doctrine, and for our nation's ongoing reckoning with its racist past and present. So I'll briefly introduce our panelists. I guess I'll start on the end and work my way towards me. We've got Danny Lee. He's the author of a paper in the Yale Law Journal exploring the role of racial justice arguments in the history of the contemporary Second Amendment. He's an incoming associate at the law firm of Jenner and Block. Next to him, we have Professor Saul Cornell, who is the Paul and Diane Gunther Chair in American History at Fordham University. He's an award-winning author on American legal history and one of the nation's leading authorities on early American constitutional thought. His works have been cited by numerous courts, including the United States Supreme Court. Next to him, we have Professor Jake Charles, who writes and teaches on the Second Amendment and firearms law at Pepperdine Caruso School of Law. His primary research interests include the legal regulation of state and private violence, Second Amendment doctrine and theory, and the place of guns in the criminal legal system and in tort litigation. His scholarship has been published in leading legal journals, and his writing on firearms law and policy has been featured in outlets such as the Washington Post and LA Times. And last but not least, to my left, I have Professor Eric Rubin, who teaches at Southern Methodist University School of Law and is a fellow at the Brennan Center for Justice. His current scholarship explores the regulation of violence and weapons and how that regulation intersects with self-defense and Second Amendment rights. His work has been widely cited, including by the United States Supreme Court, and he regularly provides legal commentary to popular news outlets, including the New York Times, Washington Post, and NPR. Okay, with that introduction, I think we'll just get into it. Let's begin by talking a bit about how we got to Heller and ultimately to this year's decision in Bruen. Professor Charles, would you mind walking us through what jurisprudential conversations about the Second Amendment look like in the decades leading up to Heller and then in the 14 years between Heller and Bruen?
Yeah, of course. So first off, I want to say thank you to Esther, thanks to Giffords, and thanks to UCLA for hosting this really important conversation. I apologize that I am a little congested, but I did take 3 COVID tests, all negative, including the one this morning. Otherwise, I wouldn't be here today. So how do we get here? So let me first situate it. So Second Amendment, ratified in 1791, and for the next 217 years, it's basically inert as a matter of federal constitutional law. So it wasn't until 2008, when the Supreme Court decided DC versus Heller, that the Second Amendment actually did any work as a matter of constitutional law. What was happening in the meantime is basically we didn't have much going on for the first 100 or so years, and at least some of that was due to the fact that the Supreme Court was operating out of the assumption that the Bill of Rights were not incorporated against the states. So the states weren't bound by the Bill of Rights, and we didn't have federal regulation of firearms in the way that we do today. And so there weren't Second Amendment challenges bubbling up in the lower courts. Once we did get federal regulation in the 1930s, then we saw the first Supreme Court case, United States versus Miller, where the court wasn't entirely clear about what the Second Amendment was doing. It said instead that it didn't block this particular conviction of someone who had a sawed-off shotgun under federal regulation that made possession of those without paying a tax stamp unlawful. So from 1791 up to Miller, and then even after Miller, what was happening in the federal courts of appeals after the understanding of the Bill of Rights as incorporated against the states was changing, federal courts of appeals were still unanimous that the Second Amendment was not a right that was one that was practiced by individuals unconnected to any kind of militia service, but it was instead tied to, as the preamble suggests, some sort of militia service. So this was the big debate pre-Heller, was the individual rights reading versus the militia reading of the Second Amendment. And there were variations along those, but that was the big debate. And then Heller decided it on the side of the individual rights reading. And so what Heller said was the Second Amendment protects a right unconnected to militia service that has as its core self-defense, to have a handgun in your home for self-defense. But Heller didn't tell lower courts what they should do when evaluating new claims under the Second Amendment, what kind of methods they should use or framework they should use. It said, can't use pure interest balancing and can't use rational basis. But other than that, Heller didn't give any advice. So between Heller and Bruen, what we had was lower courts trying to develop how they're actually going to assess claims that some given law violates the Second Amendment. And what we had was 12 years of litigation in which courts, again, coalesced around a common view. And the common view was we're going to apply a two-step framework that is borrowed from how we analyze First Amendment claims. So we're first going to look at whether or not the challenged law burdens conduct that's protected by the Second Amendment. And if it does, then we're going to apply some form of heightened scrutiny, either intermediate scrutiny or strict scrutiny, depending on how burdensome the law at issue. So that's where things stood as of this summer when the Supreme Court decided to hear the Bruen case, that lower courts had coalesced around this two-part framework, that it was clear that the Second Amendment protects handgun possession in the home for self-defense, but it wasn't yet clear what it looked like outside the home, if states had more regulatory authority in public, or if they had the same as they had in the home, and what kind of method courts should use to assess Second Amendment claims.
Thanks. That's really helpful background. And before I ask Professor Rubin to tell us a bit about Bruen, I just want to mention that I'm going to save some time at the end for questions, but folks should feel free to raise their hands and ask questions, and fellow panelists should also feel free to jump in and correct or supplement or anything you'd like to say. So Professor Rubin, tell us about Bruen. What did the court decide?
Sure. Well, first, thank you to Giffords and to UCLA for inviting me to be part of this symposium. I'm really excited to be here and to be on this awesome panel. So Bruen, as Jake just teed up, was different from Heller because Bruen was asking a question about whether or not the Second Amendment protects a right to carry handguns in public, whereas Heller was limited to most narrowly addressing the question of whether or not there's a right to have a handgun in the home for self-defense. And there had been a lot of disputes, as Jake just mentioned, about whether or not the Second Amendment protects a right to carry a gun in public. Most courts either decided that it does or assumed as much. But then if so, what the extent of the right to carry a handgun in public is. At issue in Bruen was New York's policy for regulating the public carry of handguns in public. In New York State and in other states that have populations that make up about 20% of the US population, in order to carry a handgun in public, you need to get a permit. And in order to get that permit, you need to show good or proper cause. If the permit applicant wants to be able to carry a handgun virtually anywhere, then the good cause that the applicant has to show is a heightened need for self-defense, something that separates that applicant from the general public. It's not enough in New York's old regime to say, look, I have a concern that I might get attacked by a stranger, therefore I want a permit to carry a concealed handgun everywhere. That would not be good or proper cause. And the plaintiffs in the Bruen case were two men from upstate New York, from Rensselaer County. They wanted to get an unrestricted permit, but they had no heightened need for self-defense that they could show on their application. And they argued that the denial of their concealed carry permits violated their Second Amendment rights. What the Supreme Court did in Bruen was it sided with those plaintiffs in a 6-3 ideologically split decision, and they struck down New York's requirement that somebody show a heightened need for self-defense before they carry a handgun in public. Most immediately, that outcome affected New York's public carry policy, that permitting policy, and the policies of a number of other states, 6 to 8 states, depending on how you count them, which make up, again, 20% of the US population and about a third of the US urban population. Those places could no longer require a heightened need for self-defense in order to receive a permit to carry a handgun in public. That was the main teeth of the public carry regimes in these different places. At the same time that the Supreme Court struck down that policy, it also suggested that it would be permissible to restrict firearms in sensitive places, to declare certain places no-gun zones. And one of the things that we'll get to, I think, later in the panel is how a lot of legislatures have responded by designating a whole host of places as no-gun zones. So that is the narrow upshot of the Bruen case. But even more significantly is that the Supreme Court scrapped that two-part framework that Jake described that the lower courts had been applying in over 1,400 cases in the 13 years between Heller and Bruen. And so not only did Bruen have an impact on the public carry policy in New York and similar policies in other places, but it actually had implications for all regulation of weapons. Every regulation of weapons that had been upheld under that two-part approach in the decade before was now reopened to challenge on Second Amendment grounds, and the test that the Supreme Court described for whether or not a modern gun law addressing modern gun violence is constitutional under the Second Amendment is that courts had to ask whether or not the modern gun law is consistent with a U.S. and American tradition of firearm regulation. They had to point to analogous regulations as a historical matter. New York's law was it was from 1911. It was over a century old. That was not old enough. The temporal frame for this new historical analysis is around 1791, when the Second Amendment was enacted, and maybe into the 1800s. There are lots of historical gun laws out there, but how to analogize to those historical gun laws, which date to a very different era, when there were no AR-15s, when handguns made up 10% of the firearms in the country, was a question that the Supreme Court didn't provide a lot of guidance on. It said that you have to compare why the historical gun law was passed to why the modern gun law was passed, and to compare how each impinged or affected the right to armed self-defense. But that's not really substantive guidance that could guide courts on a host of questions. One of the things that the Supreme Court mentioned but didn't really provide guidance on was the fact that in order to do any sort of an analogical project, you have to decide on some principle of relevant similarity between the two things getting compared. A red shirt is like a red car in that they're both red, but if the principle of relevant similarity is things that you can put on and wear around, a red shirt is nothing like the red car. You have to decide what the principle is that are connecting the two things that are being compared. The Supreme Court didn't really provide a lot of guidance on that, and that's something that we might get to a little bit later.
Yeah, and so in presenting this, the court engaged in its own discussion of history, and we can say it was lengthy but not exactly accurate. So Professor Cornell, tell us what Justice Thomas got wrong.
How many days do we have? So first of all, let me add to the chorus of people saying thank you so much, UCLA. Thank you so much for Giffords for inviting us out here to talk about this. I am, as Esther alluded, a card-carrying historian. I do sometimes play a law professor on NPR, but I really can't claim any, I'm not a member of the union, as it were. And I'd have to say, to invoke the second greatest Marxist theorist in the history of the world, I would say that Heller was, history repeats itself, first time as tragedy, and of course second time as farce, and Bruen is the farce. Heller pretty much got almost everything wrong. I mean, if you think about it, it's almost impossible to get everything wrong, right? I mean, even if you just randomly throw dots at sources from the founding era, you would get something right. But in his infinite wisdom, Scalia got almost everything wrong. I mean, I could spend hours describing that to you. Just a few examples. So if you look at how he reads the Second Amendment, he reads it backwards, as if it was like written in Yiddish, and you went from the other side of the page. To which, of course, Justice Stevens pointed out, we have never read a constitutional text backwards. What's up with that, to quote Seinfeld, another great constitutional theorist? So it's just, and if you look at the footnote takes you to a mid-19th century treatise by Fortunatus Dworis, and you're sort of thinking as a historian, I wonder how those 18th century founders got that 19th century text so they could write the Second Amendment the way Scalia thought it should be written and understood. So, and then of course Scalia says the main purpose of the Second Amendment is individual self-defense. It turns out that actually interpersonal violence, at least among people of European descent, was not a serious problem in the era of the Second Amendment. That really only happens with the rise of handguns in the Jacksonian era. So he also assumes that people brought guns that they had, therefore guns in common use were protected, but that's the exact opposite of what the policy was. The entire structure of early American gun policy was to stop people from getting the guns they wanted, which were the guns that were useful on farms to rid your fields of pests and shoot birds, and get military quality Brown Bess muskets, which could take a bayonet and which could be useful in the kind of brutal hand-to-hand combat. So Heller got everything wrong, not that anyone really cared very much at the time, but at least Heller left open what we were going to do with this bad history. I mean, it gave us a bad history, but it told us what we couldn't do, but it didn't give us much guidance on what we should do. And of course, the courts filled in with, not surprisingly, the things that judges do know how to do, which they're taught in law school, which is to apply things like interest balancing and means end scrutiny. But then, of course, the originalists on the court said, well, we don't want to do that. We want a historical, we're originalists. And so in Bruen, what they do is they don't use anything that's originalist. They make up this new sort of pseudo-Disney-esque version of history, which they call tradition. Now, there's no evidence from the founding era of people talking about, history, text, and tradition. That's kind of a modern Federalist Society invention. And even modern originalism, the standard trinity, if you will, was not history, text, tradition. Not history, text, tradition. It was history, text, and structure. So essentially, we have this kind of pseudo-historical argument being made in Bruen. And to add insult to injury, Clarence Thomas says, and we don't actually have to get it right. We just have to use what the parties present us. And we have no obligation to actually know any history, to evaluate it, to treat anyone as any different. It's like anything that comes over the transom that's an amicus brief, it's good to go. So now what we have in the case of Bruen is this idea where it's tradition, but again, it's very weird what is tradition. So for instance, they give a lot of weight to a couple of laws from the early colonial period, which is completely different than the rest of American history, in which the population is minuscule. But then they say anything that came from the territories in the 19th century, where the population was probably greater than it was in colonial America, doesn't count. Yet, if you think about it, the territories were governed by federal law. They're the only part of the country that is required to adhere to the Second Amendment before the incorporation doctrine. But that doesn't count. And they argue that we shouldn't pay any attention to traditional English history because the American Revolution marked a sharp break from that. Yet, of course, 2 days later, we're hearing all about, Matthew Hale and Blackstone in the Dobbs decision and how we have to accept that in medieval England, abortion was a crime, which of course it wasn't. So again, the level of historical ignorance and distortion and nonsense is I don't know how we're supposed to teach this. I'm probably unusual in that I teach undergrads, graduate students, and law students. And each of those audience, when I teach these gun cases, looks at me like, are these people stupid? Are they evil? How can anyone make this kind of argument with a straight face? And I say, well, welcome to our nightmare. This is what we've created. So, we are in a very, very unusual moment, I think, where both the Supreme Court's legitimacy has been severely damaged, where the court is not displaying any of the sort of traditional judicial values, and where the Federalist Society has basically strangled every form of intelligent conservative thought. So we no longer have judicial minimalism. We don't have sort of a strong reverence for federalism, despite it being called the Federalist Society. What we have is this kind of completely inane, originalist view of the past that is completely untethered to the past. So we're kind of in a weird postmodern moment where the justices are essentially making it up and giving it a thin gloss of reality. So welcome to constitutional law in the age of Disney is probably all I can really say. Except Disney, at least, you get to ride the mountain, and have, eat really bad fast food, but with the Supreme Court, I guess you don't get to do that. So from the point of view of a historian, it's pretty horrific. And I haven't met a single historian, a serious historian who's not on the pay of the NRA, which there are some, who thinks that any of these recent decisions has any intellectual credibility. And that's kind of remarkable.
Can I add
Please.
one thing? Because Saul was holding back.
Yeah. You should see what I would say if we had a few beers and we were in the bar about these decisions.
So one concrete example that I think that I find really interesting from the Bruen case of a historical claim that's not actually backed up by any history, and that, it seems implausible, is that the Supreme Court in Bruen said that the societal problem that we're addressing today with a lot of our handgun regulations, which is urban handgun violence, existed at the founding in 1791. They dealt with the same historical society, general societal problem, but they didn't pass these sorts of laws that are being challenged today. The implication being that if they thought that this was an appropriate way, if this was part of our historical tradition, given that they were dealing with the same societal problem, they would have passed these sorts of laws. Thus, this is not part of our tradition. But as Professor Cornell was just saying, the population at the framing looked a lot different. There weren't urban areas like we understand them today. I think that New York City's, Los Angeles's population is larger than the entire country's population was in 1791. And handguns made up less than 10% of the stock. So it's, there are claims like that in the opinion that are just hard to square with what we know about history.
Well, that's a bleak setup. I'm going to ask Danny a bit about some of the historical laws that were cited by gun rights proponents, by amici in the case, and in this conversation generally. And those are laws that disarmed people historically, that disarmed Black people, that disarmed Native Americans. And so, Danny, thinking about these laws and them being cited by gun rights proponents, sort of to the effect of racial justice, what do you think are the broader implications of this debate? Does the history of disarming racial and ethnic minorities mean that we can't or shouldn't be able to regulate firearms today?
Sure. So first, I just want to echo everyone's thanks to everyone who put together this awesome event. I think I want to make 3 points initially. The first one is that gun rights activists and advocates for decades have been marshaling race-conscious arguments in favor of more expansive interpretations of the Second Amendment. One of them being the argument you just mentioned that various forms of gun regulation across history have been motivated by racial animus, have targeted specific marginalized communities. So gun rights activists frequently cite laws disarming slaves, Black codes, and Jim Crow regime laws disarming Black Americans, colonial era laws disarming Catholics and Native Americans, and even more recent laws. So in the Bruen litigation, for example, there were amicus briefs filed and other briefs arguing that the New York law at issue in Bruen was originally motivated by anti-immigrant animus or anti-Black animus as well. So but that's only one of the many different kinds of arguments that sound in racial justice that gun rights advocates have made over time. Other arguments include the racial disparities in policing and enforcement of gun regulations in communities of color. This is something that's been highlighted more recently in the Bruen litigation by the public defender's brief, but is a claim that's been around for decades. And a third prominent one is the relationship between communities of color and marginalized groups and self-defense. The general argument being that marginalized communities need guns and especially need guns for self-defense when the state is either unwilling or unable to protect them. So these claims more generally have been around for a long time, but I think Bruen is a good example of how far they've come. I think it's about a quarter of all of the briefs filed in Bruen in favor of invalidating New York's laws. New York's law made reference to one of these race-conscious arguments in favor of Second Amendment expansionism. So the second thing is, I think it's worth highlighting that all the while these advocates were making these racial justice claims, in Bruen, they were also the same people arguing that the Second Amendment that the court should adopt the history and tradition method of interpreting the Second Amendment, which erases all of these racial justice claims from constitutional interpretation. Under the history and tradition method, there's no reason why any of these arguments would carry any constitutional weight. The only thing that matters is whether gun regulation has support in history and tradition. It doesn't matter whether there are racial disparities in enforcement, whether there are discriminatory origins. It's purely history and tradition. Without means and scrutiny, without interest balancing, these kinds of consequentialist, these arguments that are arguments about the consequences of certain policies, the purposes, the reasons why legislatures enacted these policies to begin with, don't seem to matter. And then there are other reasons why we should worry about the history and tradition methods from a racial justice perspective. So for example, in the dissenting opinion in Dobbs, the recent decision overturning Roe v. Wade, the dissent highlighted, and so in Dobbs, the court also adopted a history method of interpretation applied to substantive due process, and there the dissent referred to the ways in which looking purely at history and tradition for legal authority means looking at sources of legal authority at a time in American history when many groups of people were excluded from the polity, lacked political participation, and so it means that the sources of authority that you're drawing on leave out many perspectives and voices. So from that perspective, there's a problem. But I think even specifically looking at the kinds of laws that Esther mentioned in her question, laws that, gun regulations that were enacted with discriminatory intent, the history and tradition method actually treats those laws favorably in a way. And that's because there are some litigators, and in fact, when Justice Barrett was then Judge Barrett on the circuit court, she suggested that laws, colonial era laws like the ones disarming Native Americans, like the ones disarming slaves and Catholics, those laws can be understood as creating a history and tradition of disarming people who are deemed dangerous. And even though those laws are repugnant today, we can gather from these historical laws that there is a historical tradition of disarming dangerous people that we can apply today. And in fact, after Bruen struck down, invalidated New York's licensing law, New York went back to the drawing board, came up with a new gun regulation, which I'm sure we'll talk more about, immediately subject to Second Amendment challenge. And in its reply brief, defending its new law, specifically a provision of the law that basically a character and fitness requirement for applying for a gun license, it referred expressly to these laws disarming Native Americans and Catholics as establishing a practice of disarming dangerous people. And then in a footnote said, we recognize that these laws are repugnant, but given the court's ruling in Bruen, they are relevant because they establish historical tradition. So I think it's worth considering the racial justice arguments that gun rights proponents marshal in favor of expanding Second Amendment protection from the perspective of the interpretive methodology that they themselves defend, history and tradition, which renders these claims entirely irrelevant. And the last point is, I think, zooming away from these individual arguments. I think it just points to a broader problem with the historical methodology, which is that it's entirely untethered from anything that ordinary citizens care about when it comes to the gun regulation debate. And, I think we're going to talk a lot about the workability problems with history and tradition and the problems that the court has created, leaving a lot of open questions, lack of guidance. But I think a separate question is history and tradition the kind of justification that ordinary citizens deserve for when courts strike down gun regulation that they have enacted through democratic procedure? And I think one important answer is that it is entirely untethered and unrelated to the kinds of ordinary public debates that people have about whether we should have gun regulation. Ordinary citizens are not talking about whether or not they can find a historical analogy for the kind of gun regulation that they want to enact today. Similarly, and that's just highlighted by the way that history and tradition erases racial justice claims from the calculus, erases public safety claims, erases all the claims that people ordinarily make in the debates that they have about gun regulation.
Thanks, Danny. The way that you framed that, I think, was really interesting about, like, from a normative perspective, like, is this the counterpoint that we want for the democratic process? And I just want to invite the other panelists, if anyone has thoughts, to weigh in on there, because I think that's a really key point, just on a conceptual level.
So I like the way that Danny talked about the methodology being untethered, because it's not just untethered from the way constitutionalism functions in our culture, it's untethered from the history that it invokes. So it's an invented tradition, it's not actually a real tradition. And for years and years and years, it was not coincidental that it was the years that the court was dominated by people on the left, not the right. The whole goal of conservative judicial theory was to cabin discretion, to limit the ability to raise the level of generality so that a more abstract right could be gleaned from a more concrete right. And suddenly, now that we have a conservative majority, it's okay to raise the level of generality if that serves the interests of the current conservative majority. And, the old originalism, for all of its problems, and there were many, used to make a claim that it was anchored in some kind of theory of democratic legitimacy, that, since the Constitution was adopted by some supermajority process, which, of course, excluded most of the people in this room, it was a supermajority of white men. But setting that aside temporarily, big thing to set aside, the whole purpose was to reinforce democratic procedures. This version of history, text, and tradition seems to subvert that. And that's a very, very serious and corrosive problem.
Please.
Yeah, so I think that Danny's comments were fantastic, and I want to amplify one of the points that he made about the fact that that women and non-white people were not represented in the polity in this late 1700s or into the 1800s. So if one of the goals of the Bruen decision is to make sure that modern laws comport with historical laws, and you actually had to point to a regulatory tradition, it's impossible to know what that tradition would have looked like if women and non-white people were able to vote for the elected representatives that were passing the laws that make up that tradition. And it's almost like it's an impossible counterfactual. And it's also a catch-22. Because if you actually wanted to look at what happened after women and non-white people were permitted to vote, you have to look in early years that the court has said are too modern. Even the late 1800s you can't look, and you certainly can't look after women have the franchise. That's just way too recent. And if we're trying to sort of like construct what the regulatory tradition might have looked like, that's probably not going to satisfy the judges who want concrete laws. But even if it would satisfy them, I don't know that there are enough historical sources about what people thought about guns and gun regulation to even construct this alternate historical reality. So the question, one of the questions posed for this panel on the flyer was how to give voice to the historical experience of those groups who typically have not had a voice in history through this Bruen test. And I'm somewhat at a loss for how you can do that consistent with what the court says modern Second Amendment advocates and courts deciding modern Second Amendment questions should be looking at.
Thanks. And so underlying, these are all sort of foundational problems with the methodology, but we've also touched on the unworkability of it. It's been 4 months since the decision issued, and lower courts have been grappling with Second Amendment cases that were filed before and after the decision issued. And for all the new structures imposed by the court, it created a lot more questions than answers, as you can see by this the discussion here in this panel. The Supreme Court chooses its cases, district courts don't. And they have less time, less resources to take on the challenge of applying the court's new rule. So, and Justice Breyer's dissent made this point pretty explicitly. So, Professor Charles, how have the lower courts been doing with applying the new rules? What have been the major challenges they've faced? And maybe give us some comparisons to other constitutional methodologies that those courts regularly apply.
Sure. So I think it's fair to say that there's been a lot of confusion in the lower courts since Bruen. So there's been 16 weeks since the Bruen decision, and there's been, by my count, at least 8 decisions striking down laws on Second Amendment grounds. This is a lot more disruptive in the immediate aftermath of the decision than Heller was. In the immediate aftermath of Heller, courts were being very reluctant to say that the decision was calling into question a whole bunch of other regulations besides just restricting handguns in the home for self-defense. And here, I think we see no hesitation, but yet we see really wide reasoning on how courts are getting to those conclusions. So I'll just talk about a few of those. I'll list those cases and what they struck down, and then I'll talk about a few of the problems that lower courts are confronting. So the Northern District of New York struck down provisions of New York's post-Bruen law regulating public carry and where guns can be carried. The court there said things like, sure, there is a historical tradition on restricting guns from schools, and so that's okay, but that's not analogous to summer camps, and so guns have to be allowed in summer camps. The Northern District of Texas struck down the federal law that bars those who are under felony indictment from receiving firearms during the time that they're under indictment, a law that's been on the books for a long time and was not challenged successfully after Heller. The Western District of Texas struck down a Texas law that barred those who are under 21 from carrying handguns in public. A district court in Delaware struck down Delaware's new ghost gun ban. A district court in West Virginia struck down the federal law that bars a person from possessing a firearm with an obliterated serial number. Again, another law that's been on the books for a long time and wasn't successfully challenged after Heller. And then 2 district courts in Colorado put on hold localities' assault weapons bans. And then most recently, just yesterday, we had another court in New York saying that New York's post-Bruen law barring guns from places of worship is unconstitutional. And then there's been kind of one case that has thoroughly examined the issue and upheld a new law under Bruen, and that was a case in San Jose where a federal court upheld the city's liability licensing scheme for gun owners. So that's kind of what's been happening in just the 16 weeks that we've had Bruen on the books for, and there's a lot of cases that are still percolating. There's a case challenging DC's ban on firearms on the metro that should be having a decision come down soon. And there's a couple of things that we see confusion in the lower courts on these issues. So recall that the Bruen test has kind of 2 components to it. First, Bruen says courts need to ask the question of whether or not the challenged conduct falls within the plain text of the Constitution, plain text of the Second Amendment. It doesn't give guidance for how to do that plain text inquiry, but there's clearly a step 1 plain text. And in Bruen, the court said, oh, no one's challenged that handguns are in common use. No one's challenged that these 2 particular guys challenging the regulation are law-abiding citizens. And we find that public carry is within the plain text of bear arms. So it did a plain text analysis on type of weapon, type of people, and where the guns could be carried. After that, we've seen lower courts either not doing the step 1 inquiry at all, not asking the questions of whether this conduct is within the plain text, or doing it at such a high level of generality that it's essentially meaningless. So instead of asking the question of whether or not this particular person can carry guns in public or this particular person can carry guns into a church, they're just saying things like carry guns in public, and that's within the plain text. And then one of the courts in Texas said that Bruen doesn't allow you to consider things like whether the people are part of the plain text, the person who is particularly challenging this law, only the conduct itself. I think that's a clear misreading of Bruen when you see how Bruen talks about the people, the places, and the weapon being part of the plain text inquiry. Another part of the plain text inquiry, or at least one of the threshold questions, is this question of sensitive places. So Heller announced in its decision that it was not calling into question laws barring guns from sensitive places like schools and government buildings. That's all Heller said, and then lower courts have been fleshing out how do we understand this kind of sensitive places doctrine? What are the things that makes a place sensitive, and when can the government bar guns from that place? Bruen preserved that kind of sensitive places doctrine. It didn't expand on it, but it said courts can use the historical places where guns were banned and analogize from that to find new places where government can prohibit guns. And the lower courts assessing so far post-Bruen sensitive places challenge have not been doing that analogical reasoning. They have not been assessing what the burdens were of the historical laws and the contemporary laws and what the justifications for the historical laws and the contemporary laws are. Instead, they've been either skipping the threshold question and then going on to require the government to prove historical tradition, or just saying that we didn't have laws like this that look the same in 1791, so we can't have those now. So that's kind of the first step, the plain text inquiry. And then Bruen says, all right, if there's that plain text is covered, the conduct is covered, the people are covered, the places are covered, then we move to this second step of the inquiry where we say, now the burden is on the government to show a historical tradition, or at least to show that this regulation is consistent with the nation's historical tradition. And here we have lower courts all over the map on what that actually looks like. So their Texas court said, even if we look to 1868 when the 14th Amendment was ratified, only 22 states had this kind of law in effect, and so that's not enough. So roughly half of the states, the court was saying that's insufficient. The New York case rejected that, said, I'm not going to adopt this majority of states approach. Instead, I'm going to say there has to be 3 analogous laws. Kind of no reason for why 3 was the magic number, but that's what one New York case said. The case from yesterday, or another New York court, said 7 is insufficient. So we have 3, we have 7, we have half, and kind of no reasoning for why any of those should be the relevant benchmarks. And then once you even figure out what the relevant benchmark is, courts are unclear on how widespread a law has to be. Does it have to be covering a large part of the population, or it can be a large number of states? How long-lasting it has to be. Does it have to be in effect for a long time? And what does a long time look like to establish a tradition? And then how often does it have to be enforced? Does the government have to introduce statistics showing this was actually a law that was enforced, not just a law in the books? So again, the case from yesterday where the Texas court struck down the places of worship ban, the court said the government has to prove an enduring tradition. So it cannot just be a law in effect. The government has to show how long the law was in effect and some indeterminate time under which it would be an enduring law. So I think we've seen that lower courts are kind of all over the map on what they're requiring the government to prove, when they're shifting the burden to the government, and what it looks like not only to do the analogical reasoning that Bruen said courts have to do, but even to do the historical inquiry on what a tradition looks like.
So it sounds like the lower courts have taken the high bar for the government and kind of just raised it in their own idiosyncratic way.
Yeah, I think that's right.
So I want to talk about one example of a type of law that's been challenged. You talked about a sort of spectrum of different kinds of laws, and one of those is minimum age laws, which are laws that set requirements for the age to purchase, possess, or carry a firearm publicly. There was a wave of these challenges filed just before Bruen by a particularly litigious gun rights advocacy organization. With history now in the spotlight, Professor Cornell, do you think you could tell us how these laws should fare based on the history of firearms regulation in that space?
Well, so before going into that subject, I just want to say 1 or 2 things based on what Jake just said. And I have to say, my co-panelists here are doing an absolutely phenomenal job laying out these inconsistencies in the current framework. So if you think about sensitive places, in fact, the tradition, there's no mention of sensitive places in the founding era or in our history and tradition. What you have is a discussion that, you can't carry arms before the king's ministers or in fairs or markets. Fairs and markets are sites of commerce and community activity, they are the opposite of sensitive places. So somehow, again, the court has conjured something out of thin air and transmuted a historical fact into its mirror opposite. When you talk about evidence of enforcement, the problem when there's no evidence of enforcement is, how do you tell whether or not people just obey the law? I mean, there are no challenges if people generally follow the law. And, you know, the court tends to read silence as if it's not being enforced. But in fact, there's a lot of evidence that people aren't carrying guns as frequently as we thought they did. And then this whole idea of an outlier, it seemed to me, the whole idea of federalism is that we're not supposed to have a single uniform standard across America. And I can't find any evidence from either the founding era or even in the most ardent proponents of the 14th Amendment who basically wouldn't have the 14th Amendment if the assumption was, well, this will mean a single national standard that would eviscerate state police power. The 14th Amendment would have never been adopted if that was the understanding. So the Supreme Court has foisted a vision of our constitutional past that is antithetical to almost everything in our constitutional past. It really is breathtaking. So now back to my favorite recent example, which is minors. So what the courts have done is said, well, minors, 18 to 21-year-olds were in the militia, therefore they must have had a right. Well, it's a basic principle of constitutional theory that rights are not the same as obligations. Rights impose obligations. By definition, an obligation is a correlative of a right, not a synonym. So essentially what the court has said is, you can be forced to do this and we can punish you if you don't, and that's evidence of a right. Well, I don't know any rights that, you know, basically the government can force me to exercise and punish me if I don't do it the way the government wants me to do it. That's not a right. But yet that is the principal evidence that the courts have used to say you can't limit minors. Now, the other thing is, if anyone who was adjudicating these cases knew anything about English common law, which of course they obviously don't, minors have no legal rights under English common law for all intents and purposes. They are extremely limited. They are up there with that other group that English common law treats so poorly, married women under coverture who are legally dead. And in fact, the comparison to minors is they are like women in coverture. So, you know, the idea that an obligation is evidence of a right and that people who had no rights under English common law or under the absorbed English common law in place in early America had a Second Amendment right is just kind of crazy. And one of the examples they give is, well, they must have had First Amendment rights, so they must have had Second Amendment rights. Now, the whole First Amendment, Second Amendment analogy is kind of crazy because sticks and stones may break your bones, but guns will surely kill you. I mean, there's really no analogy there, and they were never regulated the same way. But it turns out that, you know, I speculated an article and I published in the Yale Journal of Policy that, let's just imagine an example of a young man who tells his dad, I'm not joining the militia, I'm going to join a pacifist religious sect like the Quakers or the Sandemanians, one of my favorite, bizarre, or the Shakers, you know. Would that young person have been able to tell his father anything if his father said, no, you're not joining, you have to show up for militia service? And it's very clear the answer is no, that the meaning of the First Amendment in that period was entirely defined through the patriarchal authority of the head of household. And in fact, there's some great cases of people who do join the Shakers and mothers who want to get their kids out of the Shakers, but under New York law in the 19th century, the only grounds for divorce are adultery. And how do you bring a charge of adultery against a celibate sect? Kind of, you know, it's kind of like the sound of one hand clapping or something. I don't know. I mean, you can't really do that. So they're unsuccessful. So again, we have this case where people are invoking history, and it's just completely wrong. And it's not even wrong in like it's, you know, a judgment call, it's complicated. It's 100% wrong. And it's the law of the land.
So minimum age laws, like many firearms regulations, are often enforced using criminal penalties. But there are also ways for criminal laws to act as a guide or a buffer if an important gun regulation is struck down under Bruen. And I'll turn to you, Professor Rubin. Can you tell us about how you see related areas of criminal law playing a role in this evolving jurisprudence?
Yeah, sure. So one of the points that you just made, I think, often gets overlooked, which is that when we're thinking about public carry regulations or sensitive places regulations, they're typically enforced through the criminal law. I think that and I guess I'll talk about two different ways to respond to the question of about the intersection of the criminal law and the Second Amendment. One has to do with public carry regulations more specifically, and then the other is, I think, more a statement about general criminal law and the Second Amendment. But I think there had been a hope amongst some, and public defenders filed a brief on the side of the plaintiffs in Bruen. There had been a hope amongst some that if this law got struck down, it would lead to a decriminalization of public carry in a way that might then advance criminal justice reform aims. And at least thus far, it has not appeared that that is the way things are going. New York passed the law shortly after the licensing restriction got struck down, setting out a whole bunch of sensitive places, also enhancing criminal trespass law in other ways that will not abate policing, I think, in practice. And one of the things, even though it might normalize gun carry a little bit more, communities that are facing a lot of gun violence right now, there's a risk that they might see more gun violence to the extent that there is a broader, more expansive right to carry handguns in public without actually diminishing the way that those communities are policed for carrying handguns at all. That's yet to be seen. So the criminal law has been concerned with weapons for as long as the criminal law has been concerned with violence. And I'm a little bit pessimistic that that is going to change, that the criminal law will necessarily abate, certainly not because of Second Amendment arguments. Maybe criminal justice reform arguments could lead to some of the decriminalization of policies relating to having guns in public. I'm not sure the Second Amendment is necessarily going to be the best avenue for achieving that result. But another thing that I think is interesting and that might be on the horizon is focusing on other ways the criminal law intersects with the carrying of guns that haven't gotten as much attention. And this relates to doctrines like self-defense law or the way that we prosecute and try homicide cases. And to give you a couple examples, one that comes to mind for me, and I've written a short article in the Harvard Law Review Forum that talks about some of these adjacent criminal law doctrines that relate to public carry and might get more focus in the future. One that comes to mind is the dangerous weapon inference. So traditionally, going all the way back to the Second Amendment's time and continuing to today, in some jurisdictions, if somebody commits a homicide and uses a gun, then the jury receives an instruction that it can infer the mental state required for murder, traditionally malice aforethought, by the fact that a gun was used in the homicide. In other words, this lowers the prosecutor's burden. I shouldn't say it that way. It doesn't lower the prosecutor's burden, but it certainly is a disadvantageous instruction that the jury gets by the fact that a gun was used in the homicide. And interestingly, in some jurisdictions, this instruction about the deadly weapon inference is only appropriate if somebody has been persistently carrying a gun in public, but not if that person just carried a gun because of some particularized threat. So it's a disincentive to basically perpetually carry handguns in public that is being pushed not directly through the regulation of guns, but through the way the criminal law might adjudicate homicide. And I see that we got a warning about 10 minutes. I could talk more about this, but one of the things that I wouldn't be surprised to see if we get more people carrying guns and more crimes or more people are getting hurt by guns, if there's more prosecutions involving the use of gun, I could see a closer look at self-defense law, and this could go in both directions. Those who are trying to insulate the use of guns in public will really lean into stand your ground laws, self-defense immunity provisions that we've seen spreading, and places that are trying to disincentivize gun use will think about other ways to influence the law of self-defense, maybe shifting the burden back onto the defendant, the way that it traditionally was, to prove self-defense rather than requiring the prosecutor to disprove self-defense. There are other ways out there, and I talk about some of them in that paper. But I think that the intersection between the criminal law and public carry is only going to get more prominent. I don't see it diminishing because of Second Amendment case law.
If I could just add one thing, which is to emphasize the potential limits of deregulation to dampen the effects of the racially disparate impacts of gun law enforcement, even in the cases where we see judges taking a maximalist view of the Second Amendment and striking down laws. In at least two of those cases, even though they've taken really broad views, they've also at the same time upheld the federal law that bars those who have felony convictions from possessing firearms. That law is probably one of the ones that has the biggest racial disparity on those who are both have criminal convictions and then arrested for unlawfully possessing a firearm. So we have seen courts, even when they're striking down laws and granting others the rights to broadly have guns in circumstances where they previously couldn't, they're still saying, well, we're drawing the line here, even though if you look at the history is pretty similar between those laws and the laws they're striking down.
That's helpful context. So yeah, we started a few minutes late, so I'm gonna just impose on you guys one final question from our panelists, and then we'll open it up to questions. I'll start by asking Danny, and then open it up. I'd like to bring us back to talking about how Bruen's focus on history is exclusionary, which is kind of the topic of today's panel. How do you think we should give voice to the experiences of historically disarmed, silenced, and disenfranchised people in the modern constitutional analysis, and approach this doctrinally, practically, however you sort of like to think about it?
Sure. So I guess I can make two quick points. One is that we've already talked about the ways that the court's modern Second Amendment jurisprudence leaves very little room for these excluded perspectives, for these race-conscious arguments in the form of Second Amendment arguments. But at the same time, it's worth noting that the court's formal Second Amendment jurisprudence has never stopped advocates before from making these kinds of arguments, even when they didn't fit neatly into Second Amendment jurisprudence. Take, for example, the public defender's brief that we're going to be talking more about later today on a different panel. That brief doesn't make any clear attempt to make what you might call a Second Amendment argument. It's making an argument about why the court should invalidate New York's law from a racial justice perspective, but it didn't clearly fit into any pre-existing framework for how to interpret the Second Amendment. So all of these briefs have been filed over decades in cases like Heller and Bruen, making race-conscious arguments in court that didn't necessarily fit neatly into jurisprudential categories. And they were still important because they set the stakes of the debate. They helped change the terms of the debate. In Bruen, the public defender's brief made the news. It came up in oral argument. It showed up in Alito's concurrence. Alito also cited other race-conscious briefs in support of invalidating New York's law, one by Black Guns Matter. He is making all kinds of arguments in his concurrence that have nothing to do with history and tradition. And that's because these arguments change the public terms of the debate, and they highlight stakes outside of the formal jurisprudential terms. So regardless of whether or not these arguments work from a history and tradition perspective, it's still worth making these arguments in formal legal fora. And groups like the NAACP Legal Defense Fund have been doing this. In these cases, they've filed amicus briefs making race-conscious arguments in favor of gun regulation, making a lot of the arguments about how communities of color are disproportionately burdened by gun violence. But the second point is just that much of the work is going to have to happen outside of courts, and the fact that these arguments won't face friendly audiences in federal and state courts means that it's only more important for advocates of gun regulation to make racial justice arguments in the public forum, to make it clear that to counter what some people call the gun control is racist narrative. In policy debates, the fact that it's important for lawmakers to make these kinds of arguments, and just to popularize these claims, to make clear that there is a very strong racial justice claim for combating gun violence and for different kinds of gun regulation. And that's all work that happens within communities. we see that discussion yesterday when we're talking about community violence intervention, and I think it's going to be reflected in a lot of the other panels today.
Thanks, Danny. Do any of the other panelists want to? Yeah, go ahead.
So I just want to make one observation, and it's somewhat ironic, and of course historians love irony. It's one of the great advantages of being a historian because nobody ever asks you to file an ironic brief, but yet historians get to be ironic all the time. And that is that history and tradition is not really the dominant framework that was used to adjudicate gun questions. If you look at the cases that Heller cites, the dominant framework for all of the 19th century was police power. And the assumption guiding the court today seems to be there was an expiration date on the police power. And the second assumption, which is equally bizarre, is that police power is kind of like frequent flyer miles. If you don't exercise it by a certain date, you lose it. And that has never been the dominant understanding of how police power functions. And the thing that I find astonishing about this is that the actual historical tradition that they use to adjudicate these questions is the one tradition they're not using to adjudicate these things now. And it's remarkable to me.
Yeah, because I'm eager to hear if there are any audience questions, I'll just go really brief and focus on something that's outside the Second Amendment, but that is still here about on this topic of whether or not we're hearing from the voices who are affected by gun violence. So 44 states have state-level firearm preemption laws that prohibit localities in their jurisdictions from enacting any gun laws, and those probably stop lots more gun laws than the Second Amendment does, even post-Bruen. And so when we talk about what communities should be allowed to do when they're thinking about the ways to protect themselves, we should be thinking not just about the Second Amendment, but also that these firearm preemption laws stop lots of communities from enacting the gun laws they might want to enact.
Professor Rubin, you want to wrap us up before we open for questions?
Yeah, sure. I'll be really brief as well. I think that last night, the first panel, we heard about community-level intervention programs to stop violence that did not have anything to do with the Second Amendment, did not really have anything to do with the criminal justice system. And there's so many mechanisms to give voice to communities that have nothing to do with the Second Amendment. And I think that those programs have shown such great promise. And the Second Amendment tends to take a lot of the oxygen out of the room, take up a lot of space in the debate. But those programs, the programs that we heard about last night, I think, are going to be more promising in my estimation than any bold Second Amendment argument about deregulation of guns.
Well, with that, does anyone have questions for this excellent panel? Don't be intimidated. Please. So the question, just for those who couldn't hear, is what are the origins of the text history and tradition methodology?
So this is the really interesting part about the method, is that where it actually originates is from a dissent from Justice Kavanaugh when he was a judge on the DC Circuit. And when he said this is the test that courts should use, he did not say this is the test they should use because this is faithful to history, or this is the best method for constraining judicial discretion, or any kind of normative justification. He said the justification for using this test is that Heller used this test, and Heller outlawed us from using any kind of means-in scrutiny. So the entire justification when the test originated was we have to use this test as lower courts because Heller told us to use this test. And then we get to Bruen, where Bruen adopts it, and Bruen doesn't actually say much more. So Bruen doesn't justify it on first principles. It says it's more legitimate and more administrable. I think we're already seeing it's not more administrable. It doesn't say why it thinks it's more legitimate, and instead also harkens back to Heller and said Heller told us this is the way we're supposed to do it. So I think the test comes out of nothing more than courts saying this is what Heller did, but not that this is justified on first principles or by historical practice.
Now, from the point of view of constitutional history, It is a bastardized version of a test that emerged in the beginning of the 20th century in Palco versus Connecticut, and the idea that unenumerated rights can be discerned from our traditions as a people and that are essential to the idea of ordered liberty. So the irony, of course, is a doctrine that emerges among the courts at the same time that the law that is struck down emerges in the legislature is legitimate, but what the legislature did in that time period is not, but the theory that the court came up with is. So, but Jake is right. That's the best you could come up with if you were looking for a genealogy. But it's mostly the Kavanaugh dissent in Heller too that it comes into play here.
And also just one last thing. The lower courts overwhelmingly, there was broad consensus that Heller didn't say that. Heller didn't require them to do text history and tradition. Every single appellate court to consider the question decided that that was not the required test under Heller. There was a minority of dissenting judges, including the Kavanaugh dissent, that thought that text history and tradition was required by Heller, but that was, to use the outlier term, that was an outlier position amongst the federal judiciary. But alas, five justices plus one thought that that was the required approach, and that's how we do constitutional arithmetic in this country.
I'd also just add that I think, right after Bruen came out, there were conservative commentators who were like, this is great, this is so originalist. But there is a question of whether, what is the relationship between originalist methodology and history and tradition, where the originalist is interested in the original public meaning of constitutional provisions, but, there's a separate question of why historical traditions matter under an originalist methodology. So another way to answer your question is to, I guess, consider whether or not this is a proper outgrowth of originalism or whether it's something entirely different.
So we're 2 minutes away from being 5 minutes over, so I'll take one more question. Please go ahead.
I want to thank you all, such a brilliant and informative panel. I represent the ordinary citizen in the room. I'm not an attorney. I just have a daughter in law school who helped create this symposium today. So I thought it would be interesting to end on what ordinary citizens and parents who have seen their families slaughtered, all of us watching it over and over again. And I think it's so enlightening, Professor Rubin, that you're saying perhaps we need to start thinking about this not as a Second Amendment issue, or not only as, but where is the health and safety and well-being of citizens, the average citizen, to be able to walk and live and worship without fear? It's also focused on guns as opposed to the well-being of human beings living in this society. And we are really, I think, the only country in the world that has this level of death rate because of the guns. But I just wanted to just look at it from a different point of view. I'm sorry, I only have a moment. But I think that's what the ordinary citizen is asking, because they can't follow all the details of the Second Amendment law and history as fascinating and important as it is.
So the question for those who couldn't hear is, what role should individual concerns for personal health and safety play in this conversation about the gun violence epidemic?
I think that in the run-up to Bruen, there had been, and this goes all the way back to Sandy Hook and Parkland and so many tragedies, there had been a real energizing of the gun violence prevention advocates and groups like Giffords doing incredible work to mobilize people to try to address gun violence in creative ways, including through community-oriented strategies. And I think that it would be a terrible shame if Bruen rendered those activities any less energized than they had been in the past. If all of a sudden, before you try to think about a potential solution, you have to say, wait a second, but did this exist in 1791? Rather than, what could work here? let's call up Saul and ask him whether or not there are traditions that might justify this in the first
Don't do that.
instance.
Please
Do
don't
that. I will give you Saul's number. So, in terms of ordinary, of what citizens should be doing, I'm tempted to say, continue doing what you've been doing. That's, and let this litigation proceed, but continue to try to come up with strategies to address problems with public safety in your communities.
And I just want to underscore what you talked about, which is we often assess gun laws and think about gun violence in terms of people who are killed and people who are shot, and don't account for the ways in which guns in public spaces can inhibit others' speech, can inhibit others' exercise of their voting rights, and the collective harms from trauma that reverberates in communities and through generations that happens even when an individual isn't shot or killed with a gun. And so expanding the view out on why we have gun laws and why we do advocacy in favor of efforts to reduce guns in public or gun violence is broader than just the number of people who are shot and killed each year.
Yeah, and just one other quick point. We didn't get to this point just because a couple of Supreme Court justices decided to project their fantasies about American law in the past. There was a complicated interlocking set of political movements, the firearms industry, and a whole other range of factors that got us to this point. And the fact is, without a popular constitutional movement for gun safety and gun sense, we'll never be able to move the needle. And it was never always going to be about, obviously having 6 Supreme Court justices is a good thing, all things being equal, but it was never the only thing that was moving the needle. So that's clearly where the action has to be now, because, unless we start like a high cholesterol baking program for the Supreme Court, I don't really know if we're going to change the voting patterns anytime soon.
Danny, I'll give you the last word if you'd like it.
I can't follow that.
I'm sorry.
I'm sure
I
we could be here all
apologize.
day, but there are a lot of great panels coming up. So I think we'll take a break right now and don't touch your dials. There's a lot of good stuff to come. A round of applause for this panel.
I'm sorry, I shouldn't have done that to you.